has joined online. Our webinar today is being presented on the lands of the Wadawurrung people, and I wish to acknowledge them as traditional owners. I would also like to pay my respects to their elders, past and present, and Aboriginal elders of other communities who may be attending today. Going to lead in with covering some Australian-based tips, and then I'm going to hand over to Sarah to cover some international-based tips before we wrap up and take questions at the end. As we'll all appreciate, the spread of COVID-19 is having a profound impact on the global economy and impacting on many businesses and individuals who are taking the opportunity to review their IP portfolios with a view to preserving their cash reserves and their access to capital. What we're aiming to do today is to give some practical tips for reducing expenses, and if not reducing expenses, then at least controlling expenses while continuing to protect your IP during the COVID-19 pandemic. Having said that, we'd like to emphasise that although this webinar has been prompted by COVID-19 and the situation that we currently all find ourselves in, the strategies can be considered under any circumstances. And there may be a couple that should probably be considered on a reasonably regular basis, and not just under unusual circumstances. So first of all, if you haven't filed a patent application and there's no pressing commercial need or any publications imminent, then the simplest thing that you can do is to simply not file a patent application at the present time and delay filing. This non-disclosure period can be used to gather further data or modifications or improvements of the invention at hand before filing a patent application. And one of the most common issues that we have with filing patent applications, and I think that any patent attorneys who are listening today will appreciate, or perhaps commercialization managers too, is filing a patent application too early without enough data to eventually enable or support the breadth of the invention intended to be claimed. Of course, there's also the circumstances where further data is intended to be gathered in the first 12 months, and then for whatever reason that is prevented. There's something that stops you from gathering that further data. But that doesn't mean that your invention isn't protected. You can keep your invention as a trade secret, provided that you don't disclose it to anybody without a confidentiality agreement in place. Trade secrets, though, are generally directed to protecting a process because a product itself can itself be a non-confidential disclosure. So care should be taken that a product can't be reverse engineered to disclose the confidential information in the process used to make it. The classic example, which probably many of us have heard, is that of Coca-Cola. Everybody knows the product, but only a handful of people know the trade secret. And although the ingredients may be discernible from the product by analysis, the product doesn't disclose how the ingredients are combined to arrive at the product. If there is a commercial need to file a patent application, then we would take advantage of preparing and filing a provisional patent application rather than a complete application. This is because a provisional application can generally be prepared and filed for a lower cost than a complete application, which largely stems from the fact that a provisional application is designed to describe an invention, whereas a complete application defines an invention. So there's a somewhat lower threshold of disclosure required for a provisional application. Once the provisional application is filed, there's 12 months during which further data can be generated to add to the complete application at the end of the 12 months, which is what I was just talking about on the previous slide. At the end of the 12 months, you then need to decide which jurisdictions of interest you would like to get patent protection, or you can delay that selection of jurisdictions by taking advantage of the Patent Cooperation Treaty, which Sarah will touch on later. And this will give you an additional 18 or 19 months to decide which jurisdictions of interest you'll go into. So the 12 months provided by the provisional application, together with 18 or 19 months from the PCT, will provide you with 30 to 31 months to assess which markets you want to obtain patent protection for your invention, and also allowing you to manage your cash flow before the costs associated with each of those national applications start to build up. But remember, as Sarah will mention, the PC does not cover all countries in the world. At present, it covers 153 countries. If you have already filed a provisional patent application, the provisional patent application could be abandoned by allowing the provisional application to lapse passively at the end of 12 months after filing, or by withdrawing the application actively within 12 months of filing. The provisional patent application can then be refiled when your cash position improves. The advantage of this approach is that the provisional patent application's contents, so your invention as described in the provisional patent application, remains confidential, and there's minimal costs involved with abandoning the application. The disadvantages include that you lose the priority date that you've established for by your provisional application, and third party filing a patent application for a similar invention would then have an earlier priority date, so effectively beating you to the punch. Furthermore, their application would act as prior art against your later filed application. There's also the risk of additional or ill-timed non-confidential disclosures of the invention to a third party. Of course, this also assumes that you have no publication pending elsewhere, which is probably fairly common for those in the scientific fields. If you are considering this approach for withdrawing and refiling a provisional patent application to effectively extend the 12-month period available for you to generate further data and decide on a strategy to international protection, make sure that you refile the provisional application at least 1 day after withdrawing. The consequences of not doing so can be quite significant. If you do need to file a patent application, but you would like to keep it confidential, similar to the provisional patent application we discussed a moment ago, and keep it confidential for a period of time and retain some flexibility to switch to enforceable rights, then you could file a complete application in the first instance. As I mentioned, this will be more expensive than filing a provisional application, but it still will not publish until 18 months after filing. So there's confidentiality during that time. You still have the option of withdrawing within 12 months of filing if you need to extend that period or maintain confidentiality. even though it's a complete application, you can still use it as a priority document in the same way that you would use a provisional patent application. So then entering into foreign jurisdictions or filing a PCT application at the end of 12 months. But you can also, in Australia, quickly file an innovation patent divisional application to chase an infringer. Although, without going into detail, there are some changes coming into effect in August with respect to divisional applications. So I'm now going to hand over to Sarah to discuss some of the international aspects.
Hi everyone. As Malcolm said, this focuses more on when you're ready to move out of Australia only and looking at extending protection of your invention to countries elsewhere. So it brings us to tip 5. A big factor is which countries you elect to file in. By virtue of the Paris Convention, you have 12 months after filing your local or generally Australian application in which to file in overseas countries to obtain protection for your invention elsewhere. And so when you're coming up to this 12-month deadline, it's when you need to decide which countries to go in. In a perfect world, you might potentially file in as many as possible, but obviously each country has applicable filing costs. So the more that you choose, the higher your costs are going to be. And similarly, renewal fees that are payable for applications and granted patents are applicable in each country where you maintain your patents. So these add to the costs and sort of exponentially increase depending on how many countries you have chosen. So give some consideration to only those countries that are key commercial markets. For example, where you're going to sell your invention or where you're going to manufacture. Another important consideration is where your competitors have a presence. So even if you don't necessarily intend to commercialise in a particular country, you might wish to exclude a competitor from being able to take advantage of your invention by protecting it in that country. Also, think about the countries that have established patent laws so that you can enforce your rights once you have them. It's all about maximising your patent's potential on a manageable budget. Ideally, you want to avoid unnecessary spending, and since the filing costs are generally one of the biggest costs that you'll face in the lifetime of your application, this is when you have to do a considered cost versus benefit analysis. Being selective with the countries you choose obviously means a smaller investment at the time, but remember that after time limits are expired, you can't add countries later. Okay, there are two main pathways for protecting your invention in countries other than Australia once you're ready to expand. As mentioned, this is at the 12-month stage after your initial filing. The two ways are the Patent Cooperation Treaty, or PCT, as Malcolm touched on, and the second is direct filing, which is filing a regular application directly into another country, not using the PCT. The next few slides do mainly focus on the PCT strategy because direct filing is really only cheaper if you're looking at between about 1 and 3 other countries. And so what we talk about moving on is mostly about the PCT application, since it's cost effective for a larger number of countries. A big benefit of using the PCT system is that you delay the payment of those national filing applications by up to 30 or 31 months from the date that your initial Australian application was filed. In contrast, direct filing, you have to do it at that 12-month date. And again, as Malcolm mentioned, remember that the PCT can only be used to file in the member countries. Some countries of note that aren't members and so aren't available to protect your invention through the PCT are Argentina, Fiji and Taiwan. So our next tip is to stagger your national or regional phase entries, which is the applications that are in particular countries from the PCT application. If you're filing in multiple countries, you can stagger when you make those applications, so that potentially you can delay them as long as possible for a time when your cash position is better, if you need to do so. So as an example, Australia, New Zealand and Europe have a 31-month deadline from the day that your original Australian application is filed. The USA is only 30 months and China, for example, is 32. So that at least puts month delays between a few of the applications that you need to file. There's no requirement that you have to wait until the very last deadline, which is, for example, 31 months in Australia and New Zealand. So that if you want to spread out the biggest costs, you can start to file in particular countries earlier than 30, 31, 32 months. So in that way, you can spread out the costs of those national filings. Tip number 8, consider withdrawing your priority claim during the PCT stage. As I mentioned, you have 31 months from the initial filing date to file your national application in Australia. So if you withdraw your priority claim, then you essentially buy yourself another 12 months, since the date that you filed your PCT application will become your priority date. This tactic is applicable if you've got a PCT application, obviously, and your priority application hasn't been published yet, because that can become a very big issue if it has. It's a means by which to delay those big costs of your national phase entries by another 12 months. Like I said, you will lose your earlier priority date. It will become 12 months later. So you really need to consider whether any prior art becomes an issue because of your later priority date. Okay, this tip is for those who have or are looking to file in the US. Dependent on the size of the applicant entity, there are different costs. So if you are a small or micro entity, then there's a significant discount on a lot of the USPTO official fees. Check whether you're eligible for small or micro entity status so that you can be applicable for paying the lower fees, and also make sure that the USPTO has your correct entity status on record so that they apply the lower fees if they're applicable to you. Next tip, renewal fees. As I mentioned earlier, renewal fees are payable in most countries And generally, like in Australia and New Zealand, most countries, the costs increase depending on the age of your patent. So if your patent or application becomes due for renewal, put some thought into whether it's still worth the cost of the renewal. For example, if you have quite an aging patent, and it starts to incur the higher renewal fees because it's getting towards the end of its 20-year lifetime, really think about whether you're making money from the product or process that you have protected, so that you know whether or not it's worth renewing. Also think about, rather than whether or not you're necessarily making money from the patented invention, whether or not you still would gain a benefit from excluding a competitor by having that patent renewed. And tip 11 is more of a, I guess, cash making tip than cash saving tip. Even if you're not making an income from your invention, consider whether it's maybe valuable to someone else. In such a way, you might be able to license your invention to another party so that, for example, they pay you royalties for being able to exploit their invention. In such a way, you can have a new source of income that you perhaps didn't consider previously. If you're looking for who might be interested in licensing to be able to use your invention, we do have analytics tools that can locate interested parties or potential interested parties. And I think this is where I hand back over to Malcolm.
Thanks, Sarah. So, as we've mentioned, patent offices around the world are conscious of the business impact. Just gone one slide too many. The business impact that COVID-19 is having, and many of them have provided extensions for deadlines for certain actions during the patenting process, and some have also waived fees. The information below should be up to date, because I looked at it this morning to confirm. For example, in the US, under the US CARES Act, for small and micro entities that Sarah mentioned a moment ago, any filings that are due by the 1st of June, so 3 days ago, are now extended to the 1st of July, and this is automatic. Large entities are still going to be considered on a case-by-case basis. But for all entities, so micro, small and large, the petition fee for the revival of an application that's been abandoned in US language, or may have lapsed unintentionally because of COVID-19, the USPT is waiving the fee for that petition for reinstatement, provided that there's a statement indicating how the abandonment or the lapse was related to COVID-19. In Europe, the European Patent Office had a blanket extension in place, but that expired on the 2nd of June 2020, so 2 days ago. But they still have case-by-case remedies available. So if you need extensions, then there's certainly a possibility of looking into obtaining those extensions. What the EPO is doing, though, is with respect to renewal fees, in Europe, even if you're 1 day late in paying your renewal fee, there's a 50% surcharge payable to late pay your renewal fee. But as of the 1st of June, renewal fees that are due on or after the 15th of March and up until the 31st of August will have the late fee waived. So that can be a considerable saving, particularly if you have a portfolio with some older European applications. There is always the risk of unintended consequences, which most of us will appreciate from the recent JobKeeper announcements. So to be on the safe side, if you can stick to the original deadlines, then it's always a good idea to try and stick to those deadlines. I think I'm sure some people may disagree with me, but that's my belt and braces approach, is to try and stick to those deadlines if you can. In Australia, we have good systems in place for requesting extensions of time, and I covered them in a webinar a few weeks ago. But these have now been streamlined via their online e-services offering, so that you can now apply online. I think it's more or less just checking a box. And then there's a one-sentence declaration needed indicating how you have been affected by COVID-19 and why your deadline has been missed, and the application fee is being waived automatically. So that's quite useful. These arrangements are going to be in place up until at least the 30th of June, but in Australia, unlike in Europe perhaps, this extension isn't applying to extensions for paying the renewal fees. Those late fees will still be payable, but just note the Australian late fees are monthly, whereas the European fees that have been waived are just a flat fee. IPONS, the New Zealand Patent Office, has been offering 3-month extensions proactively. So they've been sending out correspondence to applicants on applications where an extension is available. But just be careful of those, because our understanding is that they are preliminary extensions, and you still need to file a statement indicating why the extension is needed and how it relates to COVID-19. So best check that that criteria has been fulfilled and that it hasn't just been taken as granted. So that brings us to the end of our tips. Hopefully there's at least something in there that that can help people out there under the current circumstances. And if you've got any questions now, feel free to ask them. And if not, we're always available for taking inquiries via email.
I do think that we have a couple of questions that have come through. One from Jessica. What analytical tools are available to identify relevant parties for licensing out a patent? That's a good question. We have patent landscaping software, which we basically enter in subject matter or subject matter classification codes and have a look at other applicants who are interested in the same or similar spaces, so that we can really see which other parties are filing applications in the same sort of technical area as what your subject matter is. So that can really give us an idea of who might be interested in potentially partnering with you or licensing your invention, so that you can, collaborate or potentially generate an income from your patent applications. We can get, definitely, if you want a bit more information on the landscaping and the analytical tools, let us know and we can provide that to you. And also from someone else, I discussed staggering of national phase entries. What is the earliest that national phase can be entered for any one country? Is it any time after the PCT has been published? I do believe that it can be as early as is requested by the applicant, and perhaps it's not necessarily a requirement that it has to be after the PCT has been published, but you will then have to provide a copy with your application because it clearly won't be able to be obtained by the office of the country that you are entering. And that might be it. Anything more to add, Malcolm?
No, I'm going to have to get you to read out any questions for me. I'm having a slight technical hitch here.
That's right. It was just those two, so I believe, yeah. Okay, if that's everything, then thanks everyone for attending. Hope you learnt some interesting tips, and please do let us know if you have any more information that you need, and we'll be happy to help you out with that.
Thank you.